Okay, committee, we're going to go ahead and open up the hearing on House Bill 2784, transferring authority for certification of continuing care retirement communities from the Kansas Insurance Department to the Kansas Department of Aging and Disability Services and lowering the nursing facility provider assessment for continuing care retirement communities. I will provide a caveat on that last sentence, lowering the nursing facility provider assessment for continuing care. I made an error when this bill got drafted in not reading some language that got inserted. I am not touching those assessments, and there will be an amendment. So if you've got testimony that is all about that, rest assured we're going to address it, but just make sure when we get to the amendment that you're all paying attention to it. So, committee, we'll open up with our first proponent, which is Eric Turek, Director of Government and Public Affairs, Kansas Department of Insurance. Oh, Jenna. Wait a minute, yeah. I'm moving too fast. I got slowed down. Our reviser, Jenna Moyer, will explain it first.
Thank you, Madam Chair. Members of the committee, House Bill 2784 concerns adult care homes relating to continuing care retirement communities. And because that's a mouthful, I'm going to be saying CCRCs instead. Otherwise, you'll hear me tripping over my words probably multiple times. So the first section of this bill amends KSA 39923, which is the definition section for the adult care home statutes. And it adds in a definition of continuing care retirement community, which would be defined as a place or facility combining a range of housing and services to encompass the continuum of aging care needs at an independent living facility, assisted living facility, residential health care facility, and skilled nursing care facility, all in a single place or facility to avoid the need for residents to relocate to a separate place or facility. The provision of community care includes the multiple levels of care provided within a CCRC. And then Section 2 amends KSA 39936 to update references to CCRCs and that definition. Section 3, it's amending Chapter 40, which are insurance statutes. Currently, continuing care retirement communities are governed and licensed by the Kansas Insurance Department. And this updates references to change those to the secretary, who would be the Secretary for Aging and Disability Services. So those conforming amendments are made in Section 3 as well as Section 4, KSA 402232, Section 5, KSA 402233, and Section 6, KSA 402234. Section 5 also adds a requirement that the provider's annual disclosure statement would be submitted on or before April 1st of each year. And Section 7 also references that requirement that the related to the payments of the continuation fees would also be due on or before April 1st of that first year. Section 8 just changes the reference from the commissioner to the secretary related to adoption of rules and regulations to carry out the provisions of this act. And Section 9 amends KSA 757435. And in this section, references to the rules and regulations in regards to CCRCs were adopted from that regulation to put into the statute. That's where all of those definitions come from. The definitions of agent, CCRCs, high Medicaid volume licensed bed nursing facility, as well as skilled nursing facility and small skilled nursing facility. And then there's also changes related to those provider assessments, which the chair already spoke about, so I won't go into too much detail there. And the rest of the changes are conforming amendments, just changing the name of quality care to nursing facility provider assessment. So those are just technical wording changes, is everything else that you see. But generally, this does just change the regulation for CCRCs from the insurance department to KDADS.
Thank you. Are there questions for Jenna? All right, seeing none, thank you very much, Jenna. Now let's go back to Eric Turek from the Insurance Department. Welcome to committee, Eric. Good to see you back.
Good to see you too, Madam Chair, members of the committee. Eric Turek from the Kansas Insurance Department. We appreciate the opportunity to provide proponent testimony on House Bill 2784. And I do want to lead my testimony by making it known that the department is only in support of the components of the bill that speak to the transfer of authority from the insurance department to the secretary, or from the commissioner to the Secretary for Aging and Disability Services. The other components the department does not have a position on. A little bit of history about CCRCs and the insurance department, and then I'll stand for questions. Since I think about the 80s, the department has been responsible for the registration of CCRCs. The registration process includes a $50 fee, a sample contract between a user of the facility and the facility itself, financial audits and statements and things like that, and then basic business information. Aside from that, the Kansas Insurance Department does not regulate CCRCs beyond the registration process. The insurance department we really focus on the regulation of insurance and securities, and KDADS is already regulating these CCRCs. KDADS is a much more fitting agency to assume this responsibility, and we've been working with them since, I think, October of last year so that they have a full understanding of what the registration process entails. So I'm happy to stand for questions.
All right, we'll go through our proponents, and then we'll bring them up individually. Next, I have Steve Anderson, the Kansas Medicaid Inspector General. Welcome to committee.
Thank you, Madam Chair. Committee members of the committee, happy to be here today. I'm Steve Anderson, Medicaid Inspector General, and we are here obviously talking in favor of this the change. Just want to say that Office of Medicaid Inspector General is wrapping up its audit that we're conducting on the CCRC issue, as well as the continuing provider registration application process. Our audit's also looking at the assessment of the eligibility for reduced rate for nursing facilities, otherwise known as the provider or bed tax, for any CCP registration certificate holder. We got involved in this because KID sent a memorandum to Chair Landwehr and to the KDADS requesting assistance or changing the CCP registration process from them to KDADS because it does not fit within their area of expertise. We also talked to the director that handled the registrations, and she concurred that it was a problem processing those. And our review of the files that we took a look at found an issue with registrations being incomplete, found a 68% error rate with the registrations. Most of them lacked a required audit. It has to be certified by a certified public auditor, and those were not there. Consequently, letters of approval were given that probably shouldn't have been. And so it is our recommendation that it be moved over to the KDAD Surveying, Certification, and Credentialing Commission, and then the processing of the actual collection of the bed tax stay with the KDAD's Long-Term Service and Support Commission, which they already do that. These two commissions already share a application called CODA. That's the Kansas Organization Tracking Application. This is where they track those facilities and do that. This will make the transition should make it very easy for them, much smoother than trying to deal with a different agency or a contractor. We also talked to KDAD's leadership, and they, of course, expressed their concurrence with KDAD's taking over the issue. We did feel that the KIDS handling of the process also was an indication that perhaps it should go to a different agency that would perhaps handle it more effectively. We did make recommendations to various statutes and a regulation. And I will take some of the blame, or I'll take all the blame actually, for that because I slid those in there, and Representative Chair Landwehr has been kind enough to take that on her back, but that was partially my doing because I should have made sure she was aware of it, and that's my fault. We did want to talk about the rates, but I understand that's a non-issue, but I do want to point out that because the facility is getting this bed tax cut from the 4908 down to 818, resulted in a lot of places getting that. And it ended up being lost revenue for the state of Kansas, and that revenue over the past 4 years has been over $32 million. With that, I'd be more than happy to answer questions.
All right, thank you very much, Steve. And no, you don't have to take the blame for me not reading something, so that's all on me. I appreciate it. All right, committee, that's the only two that we have for proponents. Are there questions for either one of them? All right, seeing none, you guys did a great job. I like that. Now we'll go to our opponents, and the first one I have is Linda Mowbray, President and CEO of Kansas Health Care Association and Kansas Center for Assisted. Welcome. I hope you're opposed because of my mistake.
Thank you, Chairman Landwehr. Committee members, I am Linda Mowbray, Kansas Healthcare Association, Kansas Center for Assisted Living. We represent nursing homes, assisted living, home plus. Some are CCRCs, some are not. We have not-for-profit and for-profit members all across the state. Some are independently owned, some are owned by larger corporations. I am opposed to House Bill 2784, the way it is written, and I just have a couple of points to make in addition to the ones that you're already aware of. First of all, really, we don't mind having the CCRC definition moved over to KDADS. The question that we would have is, do they have the bandwidth? Do they have the ability? And, you know, is this something that they want to participate in? But in general, you know, KDADS, we work with them on many, many things, and we think that the move over there is not problematic. One of the areas that I understand we may have issues with is on the definition of CCRC. In the page 3, new section 1, adding the independent living definition. It's in the CCRC definition, but then adding the CCRC definition to adult care home, that does put a licensure responsibility onto KDADS for independent living, and that is currently not there. And that implies that there would be licensures, fees, surveys for independent living, and currently that is not the case. Second is a question that when we define the CCRCs and we list them out, independent living, assisted living, residential health care, skilled health care, must a facility have all of those levels of care in order to qualify for a CCRC? Assisted living and residential health care are similar, but they're not the same. There are very few campuses that you will find both of those licensed. Typically, a residential health care for our world is a wing of a nursing home that has been decertified down to a lower level of care for more ambulatory individuals. My questioning on this comes from, you know, some experiences around the state as well. CCRC that's here in Topeka, long-standing CCRC campus community, they've decided not to have skilled care anymore. They have independent living, they have home plus, they have assisted living, but they don't do skilled care anymore. Will they lose their CCRC status if this were to go through? Next, in the definition of CCRC, we have, and this is in section 9. Let me skip over there, excuse me. It talks about how having any place or facility that combines a range of housing and services, skipping down to within a single place or facility to avoid the need for residents to relocate to a separate place or facility. And that is, again, page 3, section 9. That's a little problematic for me because many times CCRCs are a campus setting where you have one building for healthcare. You have another building or two for assisted living. You might have a memory care building. And independent living would rarely ever be under the same roof line as the other types of care. The way this reads, within a single place or facility to avoid the need for residents to relocate to a separate place or facility, would a campus then lose its CCRC setting? because the resident does move from a particular place or facility to another building. It's all within the same campus, it's all within the same framework, but it concerns me the way that that might come across. I'll leave the next alone because that is the changing of the price structure. Just for a little history on that, CMS has very specific guidelines for us for provider assessments, and we don't feel like changing it in this manner would meet scrutiny with CMS. And I think the agency can tell you more about that. I'm also going to skip over my testimony about the small nursing homes because, again, I think you've addressed that. And the last piece that I would say is that according to the draft data provided by the QA panel, the provider assessment, the providers paid $28.4 million into the provider assessment, and that was leveraged with FMAP money to put $53.7 million into the nursing home budget. So the provider assessment is still bringing down a great amount of funds, and if for some reason the program were to go away or if CMS would not approve our changes, that would be a horrific hole in the budget that we'd have to fill. One more comment, I apologize. Up until just a few years ago, the insurance department was not requiring audits. They were requiring compilations. Now, the language is clear that it says audit, but it had been common practice that they would accept the compilation. When that changed, our providers were not notified. They simply started getting requests for audits and then rejects of the status. I would respectfully request you consider a compilation over an audit simply because of the time involved in the audit, the money involved in the audit, the CPA's signature on the audit, and then the time that KDADs will need to spend reviewing that audit. A compilation really accomplishes nearly the same and is a much smoother, easier process. With that, thank you very much, and I will stand for questions at the appropriate time.
Thank you, Linda. Appreciate it.
Thanks.
Next, I have Rachel Monger, President and CEO of Leading Age Kansas. Welcome to committee.
Thank you so much, Madam Chair. I'm Rachel Monger, Leading Age Kansas. We're the State Association for Nonprofit and Other Mission-Focused Aging Services around the state. We are opposed to House Bill 2784, and you'll see that detailed greatly in our written testimony. But before we dive into that, and we'll keep it pretty quick, I just want to talk about what we don't oppose. So we don't oppose moving oversight of CCRCs from the insurance department to KDADs. If that's what the two agencies want, we're fine. And then we do not oppose cleaning up the CCRC statutes to better ensure the integrity of that list and the integrity of the nursing home bed tax program. As the bill stands today, we don't think that those two aims are being achieved very well. We always try to do if we come and oppose a bill, we also try to bring solutions, so you'll find those in our written testimony as well. So just very briefly, I'll run down the list of our objections. If anyone on the committee wants me to dive in deeper, I'm happy to answer questions, but very briefly, we oppose adding CCRCs to the definition of adult care home. We, much like Linda, are not huge fans of the definition that's in there for CCRC. We do think it's confusing and a bit ill-fitting. We object to changing all the financial reporting under CCRC statutes to April 1st, and we object to removing due process rights for CCRC providers who are deemed out of compliance, and of course, we are objecting to any of the changes to the bed tax program. As you will see in our written testimony, we do have a recommended solution to all of this. The reason we're offering a solution is because Leading Age Kansas is the state association who has represented CCRCs for almost 70 years now. Traditionally, CCRCs are a nonprofit model of care. That is still largely true today. And up until recent years, the vast majority of registered CCRCs in the state were our members. Today, we make up a minority of that list. And if there is some hinky things going on, we would like to see that stopped. As evidenced by us standing here today, it is hurting all of us at this point. We would like to see it cleaned up. We believe the best way to get this issue addressed is to add a clearer definition of continuing care retirement community to the CCRC statute. We have suggested one ourselves. And to delete language in the statute that creates a loophole allowing a wide variety of organizations to register as a CCRC. We think that when you tighten up the statute, it will make it easier for the agency to clean up the list of CCRCs. And once that list is cleaned up, of course, any issues that are related to the nursing home bed tax will also be cleared up in the process. So that's our testimony and suggestions for today. And of course, I'm happy to answer questions, Madam Chair.
All right, thank you. You might just stay there, Rachel, because we only had you and Linda as verbal. I have a question for you. And if you can't answer, that's fine. But is the definition of a CCRC different on the state versus the federal level?
There is no federal designation for CCRCs. Almost every state has a definition and different statutes concerning it because they're so common now, but there isn't a unified federal definition like you would see with a nursing home or something like that.
So could you, okay, then maybe you can explain that one of the issues that kind of brought this to our attention was having a facility that said that they were a CCRC in Kansas, but on their federal forms said they were not. The federal forms that they have to file.
I'm not sure. I haven't been made aware of any federal forms, but I can go back and ask our CCRCs that I know our CCRCs have been for 100 years, and ask them if there's a federal form that they know of that you would check off. I'm sorry, I don't know that.
Is skill care a key part of CCRCs?
It's a very common part. The reason why in our definition we shy away from very specific licensures is because we know what traditionally CCRCs have looked at for a long time. We are seeing some of our homes that I know one that Linda referenced, they are starting to change not the core mission, which is you provide a continuum of care when someone comes in, so they get to stay with you for the rest of their lives if that's what they want to do. But they are finding different ways to provide that care. So you might see someone who has independent living and just a skilled nursing care because they can do the 24-hour skilled care, but in the independent living, you can now bring in a lot more options for home care and home health and all of those things to kind of serve people in their homes more so they don't necessarily have to go through 3 or 4 different buildings and levels of care. So it's a very common part of a CCRC. Will it be in another 20 years? I don't know. So that's why we kind of really concentrated on let's stick to what's the actual core, is that you really are providing multiple levels of care, however they're licensed, to residents to keep them on your campus and usually with their spouse as well. That's a lot of reason why people will move to CCRCs because one spouse has different needs than the others, but they still want to be close and together.
All right. Committee questions? Representative Barth.
Thank you, Madam Chair. I think we might have the same question potentially. So I think we're going to need a little bit more overview of why we need this bill and what it's trying to do so that we have a better understanding of that at some point in time. But the question for you, Rachel, is around the bed tax that you referenced in your testimony. And I don't see anything in this bill that talks about bed tax, so I'm really confused on what you're talking about.
Oh, it's in there.
There's a big old section in there, yeah. I
Okay.
think it's
Call
75.
it in the bill because it's not
KSA.
called bed tax.
Oh, yes. In the statute, it's called the Quality Care Assessment Program. We colloquially call it,
Okay.
I'm so sorry.
That helps.
I'm used to just saying nursing home bed tax, because that literally describes what it is. It's a tax on each licensed
what you're
bed in a
changing?
nursing home.
Is that what you're changing?
That's not going to even be in there because to deal with the bed tax as we talk about it, whether it's with our hospitals or with our nursing homes, that is a discussion that has to be handled solely on its own, and that would actually go through social services budget. I don't touch that one. Does that help? Representative Bueller.
And thank you, Madam Chair. Maybe it's still a clarification. So, because I am reading through your testimony, and as we consider this bill, are we to disregard the testimony on the bed tax? And it essentially, the quote that got me was, "The perversity of Kansas robbing small rural nursing homes of resources in order to get more federal Medicaid dollars for other larger nursing homes cannot be overstated. We strongly oppose." That's the statement in her testimony that do I disregard that in terms of the hearing on the bill that we're today? I just kind of need some clarification on.
Yeah, I would say, I'm so sorry.
No, you're
no.
fine, Rachel. Go
I
ahead.
would say put that in the context of, with this bill as it stands, which we know now is going to go away. We're not going to have that part of the bill. But as it stands today, it changed the tax on those smallest homes so that they would, in fact, be losing a lot of money under the bed tax program. And so that was my point of, if you're actually taking this, if you're using a bed tax rate that's actually going to turn these homes into losers under the bed tax program, and we could do a whole bed tax 101 on how that works. It opens some old wounds for us. It was a big deal when it passed. But my point there was just in the context, if you raise the rates on these small homes, you really will be turning them into losers under that tax program, and that money is going to go out the door and never come back to them. And when it goes out the door, it's just going to go to some other larger nursing home, and we just think that's not the way a bed tax should be working.
Okay, thank you for the clarification. Thank you, Madam Chair.
Yeah, and as a person that watches the number of beds as they dwindle in Kansas, I would not take any beds away. I hate it when we actually take beds offline, but actually we've already drafted an amendment. So it would be page 13, starting with, and correct me, Jenna, line 13, which is section 9. And everything going forward to page 19 disappears. It all comes out. The amendment is drafted, is what I'm telling you. Question? Just a minute. You have a question over there? Yeah. Okay. Representative Orpeza.
Thank you, Madam Chair. My question is, if everybody else is done, for Linda.
Yeah.
Thank you. Thank you for your testimony. I didn't want to butcher your last name, so
No,
sorry.
thank
Sorry
you.
to call you by your first name. So my question is about the audit and compared to compulations. Is that what you called it? I need to know what I understand what an audit means, but the other part is what I was,
The compilation. side.
compulations, yes.
The difference.
Yes, thank you for that question. I am not an accountant by trade. I am not a CPA. My understanding is a compilation is a less formal review process, but still requires bank statements. My understanding with the whole point of having a CCRC in the insurance department is there's an entrance fee that comes along with this. And in many cases, it's first month, last month's rent, like a deposit. In some cases, it is a huge buy-in fee. And so that money is used in the future when their assets dwindle. So that money has to be put in some kind of a trust, some kind of a savings, some kind of a vehicle so that it can continue to make money. And then the holder of that money, the CCRC, is responsible then to show their due diligence and their good work with that. And with the insurance department still here, I would certainly ask them to jump in if I'm butchering some of that, because this is my understanding. So many of our homes now are not charging that huge $100,000 entry fee. They're just charging the first and the last month. We're not dealing with thousands and thousands of dollars in trust funds and securities and whatnot. So the need for that really in-depth audit is really not there.
Okay, thank you.
Committee, further questions? Representative Barth.
Thanks, Madam Chair. Linda, you had mentioned something about there was concerns with the facilities having multiple buildings and so forth, but in the bill, it has the word contiguous in there, which does mean within a boundary. So does that address the issue that you had or concern?
Thank you for that question. Never has it been an issue that there's been a campus setting. My concern is that by opening this statute and opening these definitions and whatnot, that we're leaving room for interpretation in there. And when it says that avoid the need for residents to relocate to a separate place or facility, are they not moving to a separate place or facility when they go from their little cottage over here to the skilled nursing over there? I just want to make sure that we don't open a door that we don't need to have a misinterpretation.
Committee, further questions? All right, seeing none, thank you very much, Linda. Where's my list at? All right, committee, you have written only testimony in opposition of the bill. It's Tara Mays with the Kansas Hospital Association and Mark Schulte with the Kansas Adult Care Executive Association. And then we have all right, and then we have neutral from Lacey Hunter, Commissioner Survey Certification and Credentialing. I did not see you back there. I was like, is she live or here or virtual?
I think I mean, I can go over it, but it sounds like a lot of it's going to be addressed in the amendment. So I will be quick. My name is Lacey Hunter. I'm the Commissioner of Survey Certification and Credentialing for KDADS. Thank you for the opportunity to provide neutral testimony on House Bill 2784. Makes a number of changes to the current statutes regarding continuing care retirement communities. CCRC is a national designation for facility type with multiple levels of care, ranging from independent living to skilled nursing. Oftentimes, residents are charged an upfront fee before admission or agree to a fixed price payment plan intended to cover the range of care needed for the duration of their life within the services provided by the CCRC. The bill, as it currently stands without amendments, makes several policy changes. The bill adds CCRC to the definition of adult care home. It then further defines what a CCRC is. It moves the registration of CCRCs from the Kansas Insurance Department to the Kansas Department for Aging and Disability Services. And it adjusts rates that facilities pay for the quality care assessment. House Bill 2784 creates a regulated licensure category for independent living by altering the definition of adult care home in KSA 39923A. The addition of CCRC to the definition of adult care home would require the creation and ongoing monitoring of licensure and regulatory oversight of independent living facilities and homes. That does not exist in current statute. If independent living is to be included in the definition of adult care homes, they would move an unlicensed, unregulated setting to a facility type that must comply with regulations common to all adult care homes based on the authority of KSA 39923A. Those include requiring the hiring of certified nurse aides and certified medication aides for direct care staff roles, as well as having the independent living residencies such as townhomes, apartments, or duplexes inspected by KDADS staff and the Office of the State Fire Marshal staff to ensure compliance with facility standards and life safety code requirements. KDADS supports adding the definition of CCRC to the types of facilities KDADS licenses on page 3, number 9 of House Bill 2784. House Bill 2784 also transfers the authority of certification of CCRC facilities from the Kansas Insurance Department to KDADS. KDADS is neutral on this change and leaves that policy decision up to the legislature. Additionally, Well, the rest of it's about the QCAs. Do you want me to go into it, or do you want to?
That's probably good, so I appreciate it. Okay, committee, do you have questions of Lacey? All right, seeing none, thank you very much. All right, committee, that will close the hearing right now on House Bill 2784. We will now turn our attention to House Bill 2793 and open up the hearing. And it is prohibiting healthcare providers from performing healthcare services on minors without parental consent. And we'll have Reviser Jenna Moyer explain the bill.
Thank you, Madam Chair. House Bill 2793 would prohibit healthcare providers from providing healthcare services to minors without parental consent. This bill, most of the work is done in the definitions. The first, which are in subsection A, the definition of healthcare provider actually references a statute, and that, if you go to that statute, references another statute, but essentially, this would include any healthcare provider you can think of. It would be licensees of the Board of Healing Arts, dentists, nurses, optometrists, physical therapists, pharmacists, all the licensees of the Behavioral Sciences Regulatory Board, so social workers, counselors, behavioral analysts, and most healthcare entities would be covered under the definition of healthcare provider. Healthcare service would be a service that a healthcare provider is authorized to perform on another individual that's within the scope of their practice. And then minor and parent mean someone under 18 years old, and then a parent includes both your parents as well as guardian or anyone with legal authority to act on behalf of a child. Subsection B specifies that except as provided in C, notwithstanding any other provision of law, that a healthcare provider shall not perform a healthcare service on a minor without the consent of a minor's parent, and a healthcare provider who violates those provisions would be subject to professional discipline from the appropriate licensing agency. And I will note that you can mark this on the calendar because this is the date that I made a mistake on a bill that's before you. I missed a letter, and it should be the additional sections repealed. Instead of 38-123, it should be 38-123B. So if we work this bill, I apologize, we'll have to add that one letter in there. And that statute is the consent by a minor to a hospital for medical, surgical treatment or procedures. And so there would be two statutes that would be repealed, which you do not see in the text of this bill, but those statutes would be a minor consenting to treatment at a hospital for hospital procedures or surgery, as well as 65-2892, which is examination and treatment of minors for drug abuse, misuse, or addiction. So essentially, the gist of this bill is that a minor cannot consent to medical treatment unless it's in one of these exceptions in subsection C. And those provisions are, the first one is 38-122, and that would be consent for surgery on your own child. So a minor, so if you're a 16-year-old mom and you have a child, you could consent to your child's medical treatment. 38-123, this would also be exempt, would be if you were an unmarried pregnant minor, you could consent to your own medical care regarding your pregnancy. I would also exempt the provisions of KSA 38-137, which are provisions related to consent for immunization by a person other than a parent. 38-2216, which relates to healthcare for children in need of care. KSA 38-2217 relates to child physical, mental, or sexual abuse. The consent of a parent would not be required to do a medical examination to confirm that abuse. KSA 65-2891, that's emergency healthcare by healthcare providers. And KSA 65-6704 and 6705 relate to abortions upon a minor. Those are the statutes regarding the specific counseling. And then there's a lengthy provision already set out in statute for the very rare circumstances in which a minor could consent to an abortion without the consent of a parent. I'll be happy to answer any questions.
All right, Jenna, on the 38-123, is that on line 30 or on line 32 that the B will be inserted?
So it would be on lines 4 and 32. And so then the title of the bill, we tell you the statute that it amends and repeals, and then the bottom, we say the same thing, the statute that it repeals. My apologies for that error.
Well, yours is a lot smaller than mine, so we're good. Committee, are there questions of the reviser? Representative Burkamp.
Thank you, Madam Chairwoman. Just to clarify, would 652891, is that kind of like the Good Samaritan law, more or less?
That's part of it, yes, but it does not require that it be at, it can occur in a hospital as well. It's the general emergency care. So a healthcare provider may in good faith render emergency care assistance during an emergency, whether it's for payment or without payment, no matter where it occurs.
Okay, thank you.
Representative Woodard.
Thank you, Madam Chair. I probably should have looked at the agenda before saying yes to subbing on the committee, but here we are. Jenna, thank you for going through the different statutes and outlining what those are, not being on the committee normally. But looking at this bill where it mentions healthcare services, are there currently any procedures or services that are allowed for minors that with this bill, if it were enacted, that would no longer be allowed to take place without the consent of a parent?
Yes, so there are a lot of healthcare procedures to which a 16-year-old could currently consent to, and that would be in statute 38123B, and which is one of the statutes that I meant to repeal, but it would say that a minor 16 years of age, if no parent or guardian is immediately available, may give consent to the performance and furnishing of hospital, medical, or surgical treatment or procedures, and such consent shall not be to disaffirmance because of minority, and excuse the dated language, this was written in 1969, but essentially a minor can consent to many medical treatments, and under this they would not.
Thank you. Thank you, Madam Chair.
Representative Orpeza.
Thank you, Madam Chair. And with the way this is written as of today, would this only apply in hospitals?
No.
Or throughout schools, et cetera?
If anyone is a healthcare provider, which would be,
Any setting?
yeah, any setting, yes, as
Okay.
well as at those facilities. So it's limited at both the facility and the provider, if that makes sense. So it can't be done at a hospital, but it also can't be done, a social worker doing a therapy appointment in a school building would also be prohibited.
Okay, thank you.
Representative McDonald.
Thank you, Madam Chair. You're getting better at my name. Does this bill, if it passed, not conflict with the bill that we passed out of this committee on Tuesday, February 6th with no dissent, HB 2547, which authorizes schools to maintain emergency medical kits and administer medicine in emergencies? Like, I'm thinking specifically of a school nurse.
So, thank you, Madam Chair. It would depend on your definition of emergency. So a healthcare provider would be authorized to act in an emergency. And it would be up to that healthcare provider to decide whether or not a child, in anaphylactic shock would be considered an emergency.
Is there a legal definition in Kansas of immediate action versus emergency care?
Not that I'm aware of. I can double check.
Thank
Get
you.
back to you.
Committee, are there further questions of the reviser? All right, Representative Barth.
Thank you, Madam Chair. And Representative McDonald asked one of my questions, which is about emergencies. The other question I have, there's two questions. So what is an acceptable format of consent for a provider?
It would be consent in fact, whether express or a parent. And so it would be up to the healthcare provider to decide, but it does not specify that we're required to be in writing, so a parent calling and making an appointment for a child at a physician would likely be express consent.
Okay, and then that answers that question. The other one I had was around the discipline of a healthcare provider. Is there any type of legal type of discipline that is standard for healthcare providers' appropriate licensing agency? Around this?
When you say legal action,
Or
there's
legal,
no, there's not a civil cause of action, so you couldn't have a lawsuit over this, but each individual licensing entity has their own ways in which they discipline their licensees, and that could be anything from an informal censure to a temporary suspension or revocation of license. And it would be up to those licensing entities to decide how severe the violation was to what discipline is warranted.
Okay, I did think of one other question, if you don't mind. On line 29C, where it says the provisions of this section shall not apply, so all of these statutes here, well, the 1, 2, 3, 4, 5, 6, 7, 8 of them do not apply, and it's the next 32 not apply as well?
Wait,
Or
say
is
that
that
last part
separate?
again. So it's kind of confusing. So there are two statutes that would be repealed, meaning they are not law anymore, you should not follow them, and then these 7 or 8 statutes that this bill does not apply to, and so those, we would stay interpreting them as we are today.
All right, thanks.
Representing McDonald.
And this kind of ties in with Representative Barth's question. It's a little difficult for me to recall all 7 or 8 that don't apply, but like currently, teenagers could obtain birth control medication without parental consent. Does it change that?
Yes.
Okay.
Committee, are further questions? Representative Orpeza, you're on a roll today.
Thank you, Madam Chair. I just have one more question. So in regards to the boards, that amendments there into line 12 through 14, you mentioned the Board of Healing Arts, but it's not listed here.
Yes. So a healthcare provider, it would be everyone who's listed under KSA 654921. And so if you go to that statute, it has this whole big list. And then it also references another statute, which has another whole big list. But essentially, any healthcare provider that you can possibly think of, they're included in this bill. So everyone licensed by the Board of Healing Arts, nurses, pharmacists, dentists, podiatrists, optometrists, they're all included. They're not allowed to perform anything on children unless it's in this accepted statutes.
Okay, it's just the 2 were listed, so it's a little interesting. Okay, thank you. Appreciate that.
Thank you. Are there further questions for the reviser? All right, seeing none, thank you very much. Okay, committee, the first conferee we have would be Representative Ron Bryce, Kansas representative. Welcome to committee, Ron.
Thank you, Madam Chair and committee members. It's an honor for me to stand here and speak and express my support for House Bill 2793 today. And just to give you some context, some people here know me, some don't, but I have experience working in emergency rooms, in private practice, and in academic settings as a medical school professor, treating patients of all ages, including children. And I've worked on the issue of informed consent since I started working in hospitals as an orderly in 1978. So that, I hate to calculate how many years that is. This bill really revolves around the idea of informed consent. And informed consent, just to summarize, means that a patient or someone on behalf of a patient is given information about medical care, and the person either agrees to it or they don't agree to have the care. And of course, in a setting like an emergency room, it's sometimes necessary to treat without informed consent. However, if, for instance, a child has multiple trauma and their life is threatened, as the reviser mentioned, we go ahead and treat. As soon as the parents show up, one of the first things they get is a consent form or else a verbal to have consent for what we've already done in a life and death situation. So with that kind of experience over many, many years, I was very skeptical at first when I had a constituent come to me about a year ago, and she described how her 14-year-old daughter was being treated for medical care at a clinic without her knowledge or consent. And I didn't believe her. I have to admit I didn't believe her at first because in my experience, I haven't worked in a situation where we did that. And so a couple of other constituents came to me with similar complaints about the same clinic, the same type of clinic. And I thought they might be mistaken about that. But I had legislative research, thank you for them, they do a great job, do some work, and the reviser, and I came up with the idea that there's something called the mature minor doctrine that goes into play when treating minors. And it's based on statutes, but also on case law and on Attorney General's opinion. Mature minor doctrine itself is not necessarily a statute. It's something else. It's not emancipated minor. When my constituent came to me, I thought it must be an emancipated minor issue because, you know, we've dealt with that where the minor has the ability to make their own decisions. But with the mature and minor doctrine, it's more of a vague thing, and the reviser can help me if I misspeak, but it seems to be more of a vague thing, and it varies from state to state and from location to location, and it describes how a minor can be declared mature by a social worker or a healthcare professional at the healthcare facility, and then there's no requirement for the parents to consent for medical care. Over the years, apparently, from what I can gather historically, it's advanced over time, and more opinions have been made to the point where now there's really an erosion of parental rights and consent requirements. Apparently, general care settings, well, let me just say, in my constituents' experiences, it has been contraceptive care, it's also been general medical care, and it's been mental health care. So it's kind of a wide range of things. I think probably this erosion of parental rights began with good intentions, but it kind of became a slippery slope. What I mean is if the person is providing services is the same person providing consent for the services, then there's really no informed consent. And if I could, it's difficult to explain that other than to give you kind of an absurd example, if I could, Madam Chair. Let's say you leave the State House tonight, you're going home, you go to your car, and there's a new set of tires on your car. And you wonder, where did that come from? I didn't want a new set of tires. And then you find out, well, the tire salesman consented to it. Or you go home and you have a new roof on your house. And you say, I had a couple bad shingles, I didn't consent to that, and then you find out, well, the roofing company consented. And what I'm getting at is the people providing the services, if they're also in charge of consent, then there really is no informed consent. This bill addresses the problem by giving parents the right to direct the care of their children. And again, the reviser can correct me if I misspeak about the final version of the bill. There are a lot of cross-references to different statutes, and of course, I'm not an attorney. But from what I gather, generally, it would require consent of a parent or guardian, unless the child is being overseen by a court, and in that case, the court would give consent. Or if the underage child is an emancipated minor, as far as immunization goes, there are some different consent requirements for immunization. This bill does not change immunization consent. Also, there are different consent requirements for abortion, and also this bill does not touch the consent for abortion. And it also, as we said, in the case of a multiple trauma type situation where a child is treated without consent, that again would not be changed. In my simple layman's terms, what this bill does is, and as a parent of 4 children, I feel it's important for me to make sure that for us to make sure that we don't go down the path of debasing parental rights when it comes to directing the care of our children. So this bill provides assurance that consent of a parent or guardian is required for treatment of children in the vast majority of situations, except those that we listed, and the reviser was very helpful with that. And with that, Madam Chair, I'd be happy to stand for any questions.
All right, we're going to go ahead and get through the 2 conferees, and then we'll stand for questions. Next, I have Rochelle Colombo, Executive Director, Kansas Medical Society. Welcome to committee.
Good afternoon, Madam Chair, members of the committee. I am Rochelle Colombo. I'm the Executive Director of the Kansas Medical Society, and we appreciate the opportunity to appear before you as a proponent of House Bill 2793 today. I appreciate Representative Bryce's explanation of the bill, and as well as the revisers. I realized, because when we first read it and had conversations about it, we had a lot of questions as well. But as you all know, the Kansas Medical Society represents physicians of every specialty across the state. We meet regularly to discuss policies as they're proposed and to discuss them and get input on how these things will work if put into place. And so we met with Representative Bryce and talked about the intent of this bill. And as we understand it, it's not to limit services. Again, it's to provide clarity around informed consent. And I think that the most important thing to understand is exactly what he talked about there at the end. It's to clarify and to codify that the person performing the services cannot provide consent for those services. And this is something that we would all imagine is already codified and that is clear and common sense, and that's the way it is actually working currently in practice. However, there is precedent for what he described, this mature minor doctrine, which is not established in Kansas law. It is based on an attorney general's opinion in which a child of any age could make independent decisions without that of a parent or of a guardian. And in those instances, the provider themselves would make the decision to provide informed consent on behalf of the child. It's rare. I don't believe that there's a lot of understanding that that could happen or that anybody intends for it to happen. And it was, as we talked about it within the medical society, there weren't a lot of physicians that had that occur where they were providing services or being asked to provide services for a child maybe as young as 5 of any age that could make an independent decision without that of a parent, of a guardian, and it wasn't limited to their age or to the services. So the intent of this bill, again, is not to limit services. It's to provide clarity around who can provide the informed consent for those services. The exceptions that are limited, I think, are aimed to preserve what is currently occurring. Should there need to be further clarity around a minor that is 16 or older around reproductive services, I think that would maybe be something that could be talked about because there were quite a few exceptions that were listed, and the intent being to preserve those, but certainly to say that a child younger than 16 ought not to be receiving services without the input and informed consent of their parent or guardian on their behalf. So that is the intent of the bill. We believe that this is good policy that preserves what is the current practice, and that it also encourages the patient-physician relationship. There has to be trust, ethics in that, and informed consent is inherent in that. And so we support this measure. We'd be happy to stand for questions.
All right, thank you very much, Rochelle. Next, I have Gary Morgan, private citizen. Welcome to committee, Gary.
Thank you, Madam Chair and distinguished committee members. I'm Gary Morgan from Shawnee. I'm a father and grandfather and lifelong resident of Kansas. It's absolutely insane we find ourselves here today actually needing laws to protect our children from government overreach. But I'm going to go off script. You have my written testimony, but we're here because there's been abuses. The last several years have been eye-opening for me and many parents and grandparents across this state. We've had things happen, the news is full of it, where parents are not brought into the decision-making process. You know, there's someone that thinks they know better for our children. There's stories of grooming. There's stories of talking about doing medical changes to their bodies. And I tell you, you know, there's a lot of people in Kansas that are waiting for this legislator to stand up for the rights of the parents for once. What we hear from the special interests, they don't care about the parents' rights. They care, and I don't think they care about the children's rights. I think they care about their financial interests and what's best for them and the money flow into the various organizations that benefit from some of these procedures. So I'm just here today as a father and grandfather to ask you to really consider this bill. As you've heard, it doesn't really change anything. It just is a matter of informed consent that belongs with the parents, not with some counselor, not with some school administrator. It's very clear on ER circumstances by Representative Bryce. So it's very, very clear. So I stand before you today and implore you to consider this bill and move this on to the House for consideration. Thank you.
Thank you very much. Committee, that is our in-person proponents. You do have written testimony from 1, 2, 3, 4, 5 or individuals or organizations. At this time, we'll stand for questions of the proponents. Representative Epley.
Thank you, Madam Chair, and I'll direct this at my fellow physician, Representative Bryce, who brought this to our attention. And Madam Chair, I appreciate the research and the thinking that's gone into this bill. I think it probably has some traction. You know, I practice a little different aspect of medicine, and in women's reproductive health, it's been a standard for as long, even before I was in medicine, which is a long time ago, 40 years plus, that the age of consent did go down to age 16 for reproductive choices in the state. This would change that, and I believe, as I read the bill, and make it necessary for parental consent for under 18 to get access to reproductive health. I'm not prepared today, but if and when we would work this bill, would you be receptive to considering a simple carve-out of that aspect of that? Because it's been a standard in medicine for years for young women, young ladies to be having access to birth control down to age 16. And I just want to make sure that we say that in public, everyone understands. Thank you, Madam Chair.
Representative Bryce.
Yes. Thank you, Madam Chair. Dr. Epley. Just to clarify, as far as reproductive health, this does not touch abortion as far as reproductive health. That's a whole different animal, I believe. I would be open to discussing and seeing the will of the committee on that issue. I personally think parents need to be more involved with the children, especially in things like reproductive health. And so that would be my hesitancy, but if it would make a stronger bill and would do more good, I'd be happy to take a look at that amendment. Thank you, sir.
Thank you. And again, gosh, Dr. Bryce, with all respect, I don't want to argue here in public, but I want to say that if we don't allow that or facilitate that, which has been the status quo for before I was a doctor, I worry about unwanted pregnancies and young ladies being put in even more frequent difficult situations. So that's a discussion we can have later on. I won't bore the committee any longer, but I just want you to be aware that's been part of the status quo for a long, long time. So thank you. Thank you, Madam Chair.
Representative Orpeza.
Thank you, Madam Chair. And I'm not exactly sure who to ask this question to. My concern is looking at the fiscal note. It still only mentions the Nursing Board and Science and Behavioral Science Regulatory Board. It doesn't mention anything of what Revisor Moyer had told us about the Board of Healing Arts, pharmacy, et cetera. Like, what would be the cost associated with this?
Revisor Moyer.
Yeah, I can't give sorry. Thank you, Madam Chair. I can't give explicit explanations of fiscal notes because we don't write them. But those agencies are not mentioned, but the ones mentioned do say that the bill could subject their licensees to discipline, but that they would be able to absorb those within their existing resources. If the chair has the authority to request a revised fiscal note if that's something that she feels is necessary, since it doesn't specifically mention those other licensing entities.
Which we could, but those take a while. So remember, we got a Tuesday deadline. I don't know why why all of them were in the fiscal to begin with, so.
Okay.
Being they were in
I was
the
just
bill,
wondering,
I
like,
have
if there's
no idea.
additional FTEs or things that we should be considering when we work this bill, when and if we work this bill.
I'd be surprised if there is, but it's a legit question. I'm just saying I would be surprised if there would be a need for that.
Okay. All right, thank you.
All right, thank you. Representative McDonald.
you,
Maybe by
Madam.
the time the session is over.
It's fine. I appreciate it. I have a couple things. Perhaps Representative Bryce, I could ask you the same question I had of the reviser. You know, last Tuesday, or Tuesday, February 6th, I guess that was last week, HB 2547 authorizing the schools to maintain emergency kits to administer medicines in emergencies passed out of this committee. And I had a school nurse reach out to me. She articulated that immediate action versus emergency care, there could be a little ambiguity there. School psychs, or not school psychs, sorry, social workers, school nurses, they are all reaching out right now and concerned that they won't be able to do their jobs. What is your response to all of that? And then I have a follow-up question.
Yes, thank you, Madam Chair. My understanding is that emergency care is not hindered at all because of delay in consent, so that would not be an issue. As far as nurses doing their job, I would assume there's some kind of a consent at a school that allows the children to be treated, and that would not change. Thank you.
As a follow-up, I think that there's sometimes still that discretion. For instance, at what point does a diabetic situation become an emergency?
Madam Chair, thank you. Yeah, believe it or not, it's a very ambiguous question, because one thing I learned very quickly in emergency medicine is the definition of an emergency is anything the patient thinks is an emergency, and that's actually written. And so in a similar way, it's kind of in the eye of the beholder. And so I don't believe there's any set and fast rule. If you think the child needs emergency care, then that's considered an emergency. Thank you.
If I could respond. You've just said, though, that a child has no capability to consent for themselves. So when you say if the patient thinks it's an emergency, it is, it feels like paradoxical.
I'm sorry, I did.
It feels paradoxical, like you're saying two different things at the same time. So if for instance, my 16-year-old in high school were diabetic, and he felt as if he were having a diabetic emergency, you have said that he's not capable of consenting for himself in one instance earlier. But just now you said that if he, as the patient, felt like it was an emergency, then it would be.
Madam Chair, yeah, the emergency would be determined really by the school nurse and so forth. And the consent form, just to be clear, there's no change in really consent forms, all that structure, paperwork, none of that changes. It's just the consent form on file at the school where the school nurse is able to treat the child is signed by a parent or guardian. And really that wouldn't change. Thank you.
Thank you. I have one follow-up question about mental health, if you don't mind. In the testimony, it was written testimony by Amy Campbell, Kansas Mental Health Coalition. One thing she spoke to that
Okay.
really...
Gone to the opponent yet.
Oh, I apologize.
That's all right.
My mistake.
Representative Barth. Oh, excuse me. No, wait a minute. I've got Representative Woodard, and then Haswood, and then it will be you.
Thank you, Madam Chair. I try not to make a habit of asking a bunch of questions when I sub, but this is taking me back to being the person handing the consent form in the 7 years I'd worked in non-clinical ERs and family practice offices. So this is making me kind of think about some of the implications this bill would have, and this could be for either KMS or Representative Bryce if you're up for the question, but I guess there were instances where I feel like if a patient wants healthcare services, one parent consents, but one doesn't, how do we handle that situation?
Thank you, Madam Chair. That would not change. It would still be, if there's a conflict in consent, it's with existing law as it is now. Thank you.
Which is what, if I may?
I would refer to the reviser for that, probably.
Thank you, Madam Chair. If there are two parents and they had opposing views, it would go to the family law, which would be who was ever the, no. Well, it's not necessarily custodial because it's legal custody. Yeah, so the person who has legal custody is authorized to make decisions on behalf of the child, and it references the definition of parent, which would be a parent. So it wouldn't require the consent of both parents, just one parent.
So in family law, then, do they separate, because you do have shared custody? Is one given medical rights over the other parent?
Thank you, Madam Chair. Under family law, you can have joint legal custody in which both parents would be given those rights to make decisions for their child's education or healthcare decisions,
Only
things
one
like
gets
that.
to make it.
Only one would be required to make it, if that makes sense. You only need the consent of one parent.
Right, but you
for
still
this
have the
instance.
issue of, okay, let's say you're dealing with a shared custody issue, then you've got parents on each side of that issue then.
Yes, you could.
Then who
That is a
decides?
possibility.
And these cases happen all the time. I mean, this is complicated stuff in family law.
Yeah, I mean, as the bill provides, it would require the consent of such minor's parent. So it just says one parent's consent would be required.
Representative Woodard.
Thank you, Madam Chair. So,
That was as clear as mud, wasn't it?
yeah, so a married couple with opposing views, what does the health care provider do?
Representative Epley thinks he has the answer for you.
Thank you.
Thank you, Madam Chair. Being in that situation repeatedly, if one parent gives consent, that's consent. I mean, if they have co-equal custody of the child, you go with the one that gives consent, and you ask the parents to go work it out between the two of them. Thank you.
Thank you. Thank you, Madam Chair.
As much as it could. All right, then I've got Representative Haswood.
Thank you, Madam Chair. This is for either Representative Bryce or Kansas Medical Society. So trying to quickly define everything. So consultation, would that prevent a minor from consultating with you or their school nurse if they don't have that consent?
Representative Bryce.
Thank you, Madam Chair. Could the representative explain consultating, what that means?
Well, I guess my mind goes into if they have an STD or they have something, a funny rash, and they want to run it by a healthcare professional. And I think under the definition of healthcare provider and services, it opens up also to like social workers and behavioral health services. If they're saying they're experiencing mental health, and the emergency is at the discretion of that healthcare provider, would that not be available if they don't have that parental consent at that time?
Thank you, Madam Chair. I think the confusion might be that we aren't changing the requirement for consent. We're changing who signs the form. And so the same requirement for consent at a school before a child can be seen is still in effect. It's just, say, hypothetically, a social worker can't consent for a 12-year-old. It has to be the parent. But it's the same process, same forms, there's no new consent form, there's anything. It's just the parent is the consenter. Thank you.
And one more question, if I may. So this doesn't conflict any services of like 988, any hotline services that's directly emergency, right?
Well, Madam Chair, I don't believe that would be affected at all. Thank you.
Yeah, I think Rochelle Colombo may have some input on this, if that's right.
Well, thank you, Madam Chair. Again, Rochelle Colombo, Kansas Medical Society. And I think these are very good questions, and we talked about it very quickly, but this mature minor doctrine. So again, it's not set out in statute, which is probably why it's a little confusing and we're asking a lot of questions, and it feels like, well, is a minor not going to now have access to something that they currently would? So whether they're in a school or they're calling a 988 line, or if they were seeking a service right now, the provider already has to have informed consent. And so, as Representative Bryce said, that would already be coming through a parent or through a guardian, probably the vast majority of, that's probably what every child who's getting services right now, they're working under a parent or a guardian. There are a very limited set of circumstances where a child could have that informed consent come through a social worker or through some of the other healthcare providers that are listed in this statute. And that would be because they had been declared by that individual a mature minor. So that person who is providing the services said, they're a mature minor, they can come to me, I don't have to have the consent of their parent or of their guardian. Now, we did not hear from any physicians who said that they're doing that they have kids that they're treating who have come to them that they have declared a mature minor or that they have accepted through a school nurse or through a social worker as a mature minor. I don't think it's happening a lot. So this would clarify that that's not the intent, that's not what should be happening, and that those children have, except for those exceptions that are listed out, that they have a parent or a guardian who is making informed consent with them, particularly under age 16. So I hope that clarifies that a little bit.
Thank you.
All right. Representative Barth will be the final question because I do have 4 opponents that would like to testify. Representative Barth.
Thank you, Madam Chair. And this would be for Representative Dr. Bryce. This question would be for, so first I'd like to state, I too know a parent that lives in Kansas that has had a minor in a school being pulled out of class by a social worker counselor at the school without the parent's permission, and it has not gone well. Where it actually caused mental health declination of that child in a very bad way. And so unfortunately, this is not an erosion of parental rights. I call it a total disrespect and a crossing the line of a sacred relationship. And so I'm for a lot of this. I just need to make sure I understand the exclusions and everything too.
You have a question in there somewhere?
And because it makes me kind of emotional as a parent myself, who would never dream of somebody doing this to my child, but knowing that it happens, there is a need for this law. And I just forgot my question.
That's all right. If we have time, we can come
my
back to it,
gosh.
Representative Barth, because it happens. And
I know. Why, my question came back to me. Why are we carving these out specifically? Can you give us an example of the reason behind that? Thank you.
Thank you, Madam Chair.
Representative Barth.
Thank you, Madam Chair.
Or excuse me. Bryce.
I've been called worse. For different reasons. The emancipated minor is already in statute, and some things are the revisor may correct me if I'm misspeaking again, but because a lot of these things are cross-referenced, but there are some things in federal law that surround abortion and perhaps immunizations. I'll have to check on that. But the carve-out was basically what I call common sense. You know, if there's someone dying in front of you, you don't wait for consent. And that does happen. So in that case, you don't need informed consent. I think another common sense thing is the emancipated minor. Another common sense thing is because of federal abortion law and so forth, that we really can't open up that can of worms with something like this. Although I do feel like parents do need to be more involved in these kind of decisions with their underage children. So hopefully that will be an answer. Thank you.
All right, now we're going to open up the opponent side, and I'll recognize Carol Moreland, Executive Director, Kansas Board of Nursing. Welcome to committee, Carol.
Carol Moreland, Executive Administrator for the Kansas State Board of Nursing. Madam Chair and committee members, thank you for letting me come and just kind of share a few points from the Board of Nursing. I want to start this out by saying the Board of Nursing does not oppose the importance of parental consent. However, we do oppose kind of the broad language that's part of this. And let me kind of explain that. Because this bill directs the licensing agency, that would be us for nurses, to discipline a healthcare provider when the healthcare provider performs a healthcare service on a minor without the consent of a parent. Okay. Then you have the definition of healthcare service means a service that a healthcare provider that's authorized to perform to another individual under their scope of practice for their license. Okay, so scope of practice for a nursing license is very, very broad. It can be anything from basic to advanced. And I will tell you that we got a lot of phone calls from school nurses on this, and they're wanting to know, okay, so we can be disciplined for doing basic stuff. So they gave me some examples, and I just want to share those with you. Okay, a child comes to them, they're not feeling well, okay? So they're talking to the child. The child's very flushed, warm, and so that kind of leads them down a path. So they want to assess that child, and they want to, part of that would be taking their temperature, okay? That is a service that they can do under the scope of practice for their license. So this would mean that they couldn't do that until they got a parental consent, which, okay, that's great. You pick up the phone, you try to call the parents. According to what they're sharing with me, it can be a while before they get that parent, or maybe not at all. So does that mean if they either don't treat that child, or they treat that child and then run the chance of getting disciplined from us because we're told by this bill that we have to do that? So they're sharing that there's several instances of that. So that's the concern and the opposition that we have is it seems like any service that the nurse would do that's within their scope, if they cannot get the parental consent first, they're going to get disciplined. No nurse wants to have discipline against their license. They don't. And then for the board, the role of the board then, anytime we get a complaint, if we got a complaint about this, we would investigate it, which means we're going to know two things. Was there consent of the parents? And then did the nursing action meet the definition of a healthcare service in this bill, which I've already explained, seems to be anything that's within their scope of practice as a licensed nurse. So I think there's going to be a lot of, it's going to be very confusing to the Board of Nursing that we might have to discipline someone who was providing basic nursing care when they couldn't get a parent right away. And according to them, that does happen. It's not like the parents are going to pick up the phone and answer right away, or they may not get it. So then you're looking at a nurse not being able to give basic care to that child that's sitting there that is not feeling well, maybe has a headache, maybe has a rash, whatever. These are not considered emergencies per se, but this is basic nursing care. They may not be able to provide that. So I don't know, maybe there needs to be some differentiation in here about healthcare service, or maybe, that they tried to get consent and there's a reason that they couldn't get consent. That's just the opposition that the Board of Nursing has is it's very, very broad in here. But again, we understand the importance of parental consent. That's not what we're opposing to here. That's it.
Thank you. We'll go through our opponents and we'll go stand for questions. Next, I have Dr. Dina Hubbard, Public Policy Chair, Kansas Chapter, American Academy of Pediatrics. Is she
I'm here virtually.
virtual?
Can you hear me okay?
Yes.
All right. Thank you, Madam Chair and distinguished members of the committee. I am Dr. Dina Hubbard. I am the Public Policy Chair for the Kansas Chapter of the American Academy of Pediatrics and a practicing board-certified neonatologist. I appreciate the opportunity to share our concerns. Just as the previous opponent mentioned, pediatricians also very much value parental involvement. We consider that as integral to health care for children. We recognize parents as essential partners, which normally enhances the overall quality of care through open communication and shared decision-making. The default by far is seeking parental consent for care. There are unique situations when obtaining parental consent as mandated by this bill could be problematic, potentially harmful. And I think overall there are just some unintended consequences that I anticipate. I find this very confusing. And so I think it could delay care. I think it could limit services. I think the confusion will lead to missed opportunities for care. I believe it does not encourage the patient, physician, and family relationship. Pediatricians, in terms of those represented by our group, the majority of pediatricians in the state, I would like to respectfully disagree with KMS's testimony because we respectfully disagree. We do not feel like this is in the best interest. It is very, very rare, and it sounds like some of the examples may not even be with physicians. I will tell you, as a practicing neonatologist, it is getting harder and harder to obtain consent just in general with all of the information that is available to the general public. And I noted that there was something that the consent cannot be obtained by the person performing the services. I would like some clarification on that as well, because as of right now, as a neonatologist, I have a baby that needs surgery. I would not provide that. I would not obtain that consent. The surgeon would do that. And so they would be best to do that consent. So again, we very much respect parents in the care of their children. We do have concerns about sensitive issues like substance abuse, sexually transmitted disease, reproductive health, mental health care issues, which we know is a crisis in our state and in our country at this time. And we are concerned that the unintended consequences of this bill might limit early intervention and timely access to care that's really crucial for our patients. Thank you.
All right, thank you. Next, I have Randy Kallstrom, President and CEO of Wyandotte Behavioral Health. Can you summarize for us? Thank you. Welcome to committee. Is the mic on? There we go.
There we go. Thank you. Yes, and I can summarize. Again, my name is Randy Kallstrom. I'm the CEO for the Community Mental Health Center and CCBHC in Wyandotte County, and very familiar with informed consent. Our policy, based on our attorney's recommendation, and I believe this is followed by many mental health centers and mental health providers, is based on Kansas Law 592949, which stipulates that a 14-year-old may make an application to a treatment facility, although the parent or other person in loco parentis must be immediately notified in writing. The minor may not be seen a second time unless a consent to treat a minor is signed by the parent or legal guardian. And if a parent legal guardian refuses to allow the minor to be seen, then we shall honor the request of the parent or the legal guardian. So our consent or informed consent is based on that Kansas statute. My concerns and why I'm speaking as an opponent to this bill today are some unintended consequences, because I understand the spirit of the intent, I believe. But it is critical for us to do an emergency assessment. I understand there is an emergency exception to this, but oftentimes if someone is having thoughts of suicide or thoughts of harming someone else, we don't know that until we conduct a risk assessment. So if a minor appears in a mental health facility, if we're not able to reach the parent and we're not able to do that initial risk assessment, we will not know if there's a risk of suicide or harm to others. And without that, the provider, the social worker, mental health professional would be in a conundrum of responding to the youth that is in front of them and, in essence, assuring their safety and or faced with violating the law, which could be grounds for disciplinary action. Furthermore, if we just told the youth, sorry, we can't talk to you, we can't assess you, the youth may leave. They could harm themselves, they could harm someone else, in which case the licensed mental health professional would be at risk of discipline again from the BSRB or even potential legal action for negligence. This is a strong concern that I have as a mental health professional and encourage more discussion around this. I will summarize and stop there, and we'll stand for questions at the appropriate time.
All right,
Thank you.
thank you very much, Randy. Next, I have Amy Campbell on behalf of the Kansas Mental Health Coalition, and please summarize.
Thank you,
I
Madam
know you
Chair.
can.
I apologize that I have the wrong header on my testimony. I apologize for that. This was a late night homework assignment when the hearing came up on the schedule. Just quickly, behavioral health professionals need to be prepared to screen and counsel minors in emergency or crisis situations when the parent is not immediately available. We are definitely expanding the access to this type of intervention, early intervention, which is very effective for suicide prevention among young people. Kansas has put a lot of time and effort into that planning. But I want to point out a couple of things. Children who, young people who access the 988 hotline may or may not be currently under any sort of treatment protocol or under a provider who has parental consent at that time. But these interventions are absolutely necessary to save the life of that child. And although BSRB providers are included under this statute, when I look at 65-2891, which gives the exemption under emergency care, I do not see behavioral health providers under there. So maybe I'm not reading that correctly, but that is a huge concern. Additionally, we need to define what is a healthcare service. Is that consultation in that school social worker's office, is that a healthcare service? When does that healthcare service begin when it comes to things like screening and assessment? So these are particular concerns that we have. We would really appreciate a more in-depth conversation about where that starts and ends when it comes to what we do with children. And then I would also add that you have a statute 2891B that pertains to emergency care by non-healthcare providers, and I'm not sure if that ought to be referenced in this statute. I would also point out that the statute that Randy Kallstrom has spoken about that does have to do with mental health care and mental health services specifically pertains to admission to a mental health facility. And so many of the places that we are talking about providing interventions with young people is not a facility. So with that, Madam Chair, I'd be happy to stand for questions. There's so much more research that I did. I do want to emphasize that I scanned multiple curricula for continuing medical education. The majority of that education is how to get the consent, what that needs to look like, and what that means. It is very small sections that talk about where the exemptions are. So I want to emphasize that we care about parental consent, and we do think it's important. Thank you.
All right, thank you very much, Amy. Committee, are there questions of the opponents? All right, seeing none, thank you. Oh, Representative Haswood and then Representative McDonald. And let's try to make, and I hate doing this, but we're running up to that 3:15, which messes up the next committee. Go ahead. Representative Orpeza and then Representative McDonald.
Okay, thank you, Madam Chair. And I'm hoping somebody can speak to this. Is there a consent that's taken at each school as you walk in the door, other than for like school nurses, they have the consent to, okay, give Tylenol or ibuprofen or something along those lines? Can anybody speak to that?
Carol Moreland from the Board of Nursing. What I am told from the school nurses, and I've talked to several, is that is the only consent they have, is medication, both over-the-counter and like prescription that that child might have. Other than that, just to provide other services, it's my understanding, no, there's not.
No blanketed consent. Thank you.
Representative McDonald.
Thank you. I'll be quick. Dr. Hubbard, are you still with us? Is she here or on Zoom? I can't remember. I guess any medical person could tell me, or even Representative Bryce. One thing that occurred to me is that this might put in place some barriers and delay to like teen pregnancy, like prenatal. Is that something you considered? If it was perhaps a child of 16 was pregnant but hadn't told their parents, I could see how that might prevent them from getting prenatal care that they might have otherwise gotten.
Thank you, Madam Chair. I'm unsure whether there would be any delay in care. There would still be, this doesn't change anything but the signature on the consent, basically. So it's not necessarily a delay, and the attempt is to have the parents more involved in these cases.
But if a child had not told their parents they were pregnant but came to a doctor wanting a pregnancy test even, that wouldn't be a possibility with this legislation, correct?
Thank you, Madam Chair. Yeah, pregnancy tests are very easy to obtain over the counter, so I don't believe that would be a problem. Thank you.
Revisor Moyer.
Thank you, Madam Chair. One of these statutes that is excluded from the scope of this bill would be KSA 38-123, and that allows an unmarried pregnant minor to consent to medical care related to her pregnancy.
All right. Committee, again, I apologize, but when we work this bill, we can get answers to your questions, or you might contact the individuals between now and then. So we'll close the hearing right now on 2793. Committee, Monday, because my intent is not to work any bills tomorrow, because we've got some people that are coming in via web. Not to work any bills tomorrow. We're hearing a bill because we have individuals on WebEx, and they cannot vote unless they're in the building. So we will be working bills, and I think we've got a hearing scheduled, or are they all working bills on Monday? So we'll be working bills Monday and Tuesday, and keep in mind, if we don't get done during our allotted time, we will be working in the evening. So we're adjourned till tomorrow at 9:45 in the morning.